one of the positions that most of the propagators of this gay rights are taking is that it violates fundamental human rights. I'm going to quote the U.S. Secretary of State John Kerry, who slammed Nigeria's decision on Monday when it was known that the president signed that bill into law. He said, beyond even prohibiting same-sex marriage, this law dangerously restricts freedom of assembly, association, and expression for all Nigerians. Is he correct?
The law is not only criminalizing and punishing those who are engaged in gay marriage, but those who may abet or support it by forming associations or organizations to propagate the rights of the gay. But let me provide a context. Like I said earlier on, sodomy has always been a crime in Nigerian, under Nigerian law. When the criminal code was enacted for Nigeria, most close to 100 years ago, such issues like sodomy, like bigamy, which is even a crime in Nigeria, I mean, having more than 2 wives, of course, it has not been implemented in Nigeria. They were essentially matters of domestic jurisdiction that international law was not concerned about. In fact, even when under 1945 UN Charter, when the United Nations was formed, Article 27 of the UN Charter provided that matters which are essentially within the reserved domain or domestic jurisdiction of state should not be the concern of the international community. In other words, no state is permitted to interfere in the activities of any other state on matters that are within the reserved domain. But you see, when the regime of human rights came into play, starting from 1948 with the adoption of the UDHR, Universal Declaration of Human Rights, there was a provision, apart from the ones not permitting violations of the right to association and the rest of them, there were provisions that also permitted non-discrimination. The UDHR concerned that provision. It was not a treaty, but of course it was a recommendation to state parties. The first major human rights treaty at the universal level was the International Covenant on Civil and Political Rights, followed on the same day with the International Covenant on Economic, Social and Cultural Rights. They were all adopted in 1966. And then there have been a number of universal instruments adopted after that. Even at the continent of Africa, there is the African Charter on Human and People's Rights. Article 2 of it also prohibits discrimination, and it provides grounds upon which discrimination should not occur. Such grounds include ethnicity, it includes religions, it includes sex, it includes political opinion, but it's usually an omnibus provision that says, or any other clause, or which leaves it open that if in future something occurs that may amount to discrimination in any form, then it's covered by that provision. I think what most countries does, where certain provisions, even in human rights instruments, conflict either with what they consider their cultural value or moral value or religious values, what they do is that in ratifying those treaties, they make what is called reservation to certain provisions of the treaties. Most Islamic countries do that, especially when it conflicts with certain provisions of the Sharia. So they make a reservation that we will not be bound by this provision because it conflicts either with our culture, with our morality, or with our religion. Nigeria didn't do that to any of these instruments which is ratified. That's why the international community is saying you cannot approbate and reprobate at the same time.
But that is what Nigeria is doing now.
And that is the argument of the international community. It's arguable. It's neither here nor there. I'm just setting the context so that we understand where they are coming from. Since Nigeria is a party to these treaties which prohibits discrimination on any ground, including the ones enumerated in those instruments, it means that Nigeria cannot now enact a law that purport or tend to be advancing or against the object of those treaties. But I'm just setting the position, as it is now, but not that I'm supporting either side of the equation.
Yeah, but is this issue enough to disturb relations between countries? I mean, the issue of whether or not you're trampling on people's rights, because the impression that the international community is given, specifically the US and Britain, the impression they're giving is that we're stamping on some people's rights in this country.
I think they are not competent to go their way they are going. I am of the opinion that the object and purpose of every treaty is always known even in advance. By way of extrapolation, I don't agree that there is a clause in any of these human rights instruments that will cover this inverse sexual relationship. The reason being that some people, by their nature, are given to stealing. So you will not discriminate against them because they are by nature, there are people, no matter what you do, they feel like pilfering. So you leave them to go and be stealing, and you will not discipline them. Non-discrimination clause, as far as I'm concerned, does not include a line by Africans, this particular thing, because even those reservations, like US used to apply, reservations, understandings, and declarations. If you look at the evolution of rights, you discover that, most of the papers in those days where you read about reproductive and sexual rights, mention was never made of gay rights. So in all the arguments, because before a treaty is passed...
Could it be that mention was not made of gay rights because it was not popular then? Because now it is popular.
Before any treaty is signed, there are arguments made. If you go and check the notes where all those arguments were made, none of these countries ever mentioned gay rights, even by way of extrapolation or interpolation. Beyond that, there has been more papa than papacy, because America doesn't have a federal law, like I said, and Britain had a Civil Partnership Act of 2004. It was just 17 July 2013 that Britain has Same-Sex Marriage Act. So what are we talking about? Now, America, as at last year, was 237 years. Now, and in their Supreme Court, they had a vote of 5-4 to abrogate the Defense of Marriage Act and Proposition 8 of California law on that bans people from same-sex marriage. Now, if it took them 237 years to understand the meaning of human rights, now we are 54 years. They want us to move as fast as... They should leave us to move in our own evolutionary method. And I want you to appreciate, with due respect, that America doesn't apply what they preach. Because Thomas Jefferson, as far back as 1776, that said that that we hold these truths to be self-evident, that all men are created equal, that the Creator, they have been made by their Creator, conferred by their Creator with certain unalienable rights. Among this life, liberty, and pursuit of happiness. But this same country, it was in 1964 that they passed the Civil Rights Act to allow blacks. In fact, the voting rights was 1965. So something they declared in 1776, they applied it 1960-something to everybody. That's to tell you that the sermonization on human rights, we should not get carried away, because they themselves are not practicing it.
Maybe we shouldn't get carried away here. I mean, should homosexuality or people's sexual preferences, should it be legalized? Arguing from a professional perspective, very quickly.
The state is like a father, like a parent. The state to play a paternalistic role, not only in welfare matters, but also in regulating the moral conduct of society. That's where the number of sexual offences have been criminalized. Indecent assault against children, for example, is a crime under the criminal code. In fact, under the law of most nations, rape is also a crime, under the law of Nigeria. And these are moral offences against morality. So to that extent, you can also equate this criminalization of homosexual acts as part of the duty of the state to monitor and the moral behavior of its citizens. That's one way of doing it. But there are others who are also arguing that it is not the business of the law to actually bother about the private lives of individuals. In fact, some people argue that what an individual does in private should not be the concern of society, except such acts actually bring harm to the larger society. So there are arguments on the opposing side of it. Now, let me come back to the human rights argument. We can't sustain the argument by saying that this does not violate anti-discrimination provision, because there is no law that is static. Neither the society itself is static. As we are speaking now, globalization has breached a number of things. Even in the US, what Obama is doing by secretly tapping the phone numbers of people has generated a lot of outcry, not just within the United States, but outside the United States. So we cannot really say the international community cannot ask questions about what Nigeria is doing. But Nigeria also has a sovereign right to defend its actions as a sovereign state. So we need to balance that equation. I actually think on the basis of human rights, there are two contending opinions: the theory of universalism and the theory of cultural relativism. which is that not all human rights can be regarded as universal and applicable in all contexts, irrespective of culture, religion, and morality. And therefore, certain society have a right to modify the applicability of certain human rights in order not to offend the religious sensibility, the cultural sensibility, and the moral sensibility of its people. We may place this argument within that context, but everybody has an argument at the end of the day.
I think it has not crystallized to a point that the international community will take a position. As we speak today, we don't have any international covenant or convention on gay rights. And I have not heard of
that we are party to.
Yes, and I have not heard of any convention. So it's not part of customary international law. And you realize that Western world, plus including America, they are not up to 1 billion. This is a world of 7 billion. We've not heard from the Asians. We've not heard from South America. We have not heard from many parts of the world. The fact that a section of the world, and they have not all taken this thing. UK just took it last year. America is yet to take it, except for their judiciary. They are still arguing, fighting over it. So why should we even run faster than them to go and take it up? Human rights, when we get there, for instance, they gave us religion, we took it. God created Adam and Eve. They want us to take Adam and Steve. So instead of man, woman, man, we will get to that point. Perhaps when we graduate, since it's a period of evolution, they have to be patient with us to evolve. After all, in his audacity of hope in 2006, Obama was against same-sex marriage. In 1996, when he was contesting for Senate in Illinois, he supported it. In 2012, May 9, he openly declared for it. Let us evolve the way they have been evolving.
Very interesting discussions, but I really have to stop here. Thank you so much, Professor. Thank you, Mr. Eze.
Thank you. It's nice to be here. Thank you very much.
The conversation does not end here. Now, if you go to our page on Facebook, there's quite a heated discussion on the topic. Stop by, leave a comment, or do so via our Twitter handle. I am Amarachi Ubani. I'll see you next time.